giving loans to certain entities, and they in turn bestowing favors to the private companies of the owner Samir Gehlot, the erstwhile owner Samir Gehlot.
Filed by whom?
CBI in their affidavit says that both ED as well as SEBI have found all these various siphoning of funds. Then they say that EOW Delhi, Economic Offence Wing of Delhi Police, has registered some FIR regarding this. Then they say that we are considering adding, we are investigating one of these cases regarding Yes Bank, and in that we are considering adding these 5 cases which ED has mentioned in their affidavit. 5 other cases where 5 different groups of companies were given loans by this India Bulls. India Bulls is a non-banking finance company. It has been giving loans of 1 lakh crores, virtually 1 lakh crores to various entities. What was found was that they give loans to large companies who in turn bestow favors of hundreds or thousands of crores to the private companies of the owner of India Bulls, or the main owner of India, erstwhile owner, Mr. Samir Gehlot. Now, of course, he has sold off all his shares. He has moved off to London, where he has purchased properties worth over 10,000 crores, 5-star hotels, yachts, and so on and so forth. Now, the finally the CBI says, on the suggestion of the court that we should have an SIT of CBI, ED, SFIO, SEBI, etc., we are still to take a final call. We had a meeting to consider that, but we have not yet taken a final call. And that was an affidavit in January.
No requirement of forming an SIT.
Ultimately, they also say that there is no requirement of forming an SIT. So therefore, this is a case, my lord, crying for an SIT of this kind. If your lordship just sees what the CBI affidavit said.
After that January, we are now in July end.
We are now at July end, and nothing, no affidavit thereafter, no report thereafter, nothing at all as to what has happened.
What is the status, Mr. Raju? Are you there?
Yes, I'm there. As far as EOW is concerned, we are continuing with the investigation. SFI is also now taken over investigation. SFI is also continuing with the investigation. ED has registered.
No, investigation in what?
As far as Samir Gehlot and the India Bulls matters are concerned, those investigations are, if my lords wants, I'll put a status report. SFI has started investigation in February.
No, what the CBI has done from January to July.
But as far as CBI is concerned, there was a Bombay case wherein they have applied to carry on further investigation. That is pending.
No, Mr.
CBI is, there are different facets to this matter.
Hands in glove. What is the happening?
They are not hands in glove. I'll tell my lords
Please,
what the problem is.
If we don't want to hold an investigation against an innocent person.
Therefore,
So if you have the courage to say to us that nothing has been found and therefore there is no this required matter, and
I'll tell my lords what the problem is. X amount of money has been lent to a particular person or a company on interest. That person invested in shares and made some money and returned the money with interest to India Bulls. So the question is, now we're trying to fathom is, what is the offense? The money which has been lent has come back with interest. So the issue is, what is the offense? Therefore,
investigating agency doesn't know that.
No, therefore they're investigating. They're investigating. This is the hurdle that we have to cross, because once the money is returned with interest, there would obviously be no cheating, my lords. Therefore, whether the money, giving of the money itself is an offense or not, that is what is required. I have not gone into details, but I'll take this is the basic crux of the matter, my lords. Money has been lent, returned back with interest.
Therefore, let them have the courage or courtesy or guts to say that because money has been returned, therefore no offense committed, we don't want to proceed. Then we will see what is to be done.
My lords may keep it, give me about 2 weeks' time, I'll put
We are talking January to July. What have they done?
We have taken steps, we are examining witnesses. I'll put everything on record, my lord.
No, examining witnesses, when you are saying that they don't want to, they are predicament to proceed, what?
No, I am not saying that. This was at the initial stage. Now they are investigating, they are trying to find out something, but the investigation must have realized something. I'll put it on record. I have not taken instructions. My lords may keep it after 2 weeks. I'll put my papers as far as investigation is concerned before the court and put a status report, my lords.
And who is our responsible 7? They say some new entity has taken over this and that, some affidavit has been filed.
I see for R7. R7 is well as an entity with 4.5 lakh members, public listed company, and now Manas is having the biggest investment in India, which was flagged in the Prime Minister's visit by the Sovereign Authority of Abu Dhabi in this company. It was flagged in the press conference of the Prime Minister. In fact, we are Manas concerned that we have nothing to do with this other thing. We have a press release here which I have a copy of. So if my learned friend files a response as he wants to, Manas, I will also add to that in my affidavit by then. I am a non-promoter, professionally held company in which now 2 months ago in May, the Abu Dhabi Sovereign Authority has invested 5.5 billion. Manas.
How have you associated with this company?
We are Manas, a foreign, we have got Manas now shareholders who are now investing. Earlier, I'll tell you the history. BlackRock of USA was the single largest shareholder of only 5%, which means it's a widely held company. The shareholders are 4.5 lakh in number. That company, Manas, now in terms of promoter, it's a non-promoter driven company. Now, BlackRock is overtaken by the Abu Dhabi Authority, which is investing, how many crores? 8,000 crores, of which 5,000 crores have come. In the Prime Minister's press conference, because in the UAE when he went there, it was specifically stated that the biggest investment from Abu Dhabi is coming to Samman. My name is Samman Capital. So, Manas, this is something which is just given a bad name because at one time, Mr. Gehlot had some shareholding. He has now 0 or 1% shareholding. Also, he would not have nothing. He has nothing.
Yes.
Historically, in the past, he had Manas. He doesn't have any shareholding here.
And
He is a party separately, Manas, in this
he
whole
doesn't
proceeding.
live here. He doesn't live here. He lives in England. He has no shareholding. India Bulls was the earlier name. Samman is the new name. Now we have this huge 8,000 crore investment by the
Show the press
UAE
conference.
with the blessings of the UAE.
Now not using this name of India Bull.
No.
India Bulls has changed its name to Samman.
Not only that, that is only formal.
This
Not
is
only that, the real thing is that Mr. Gehlot is not associated. Just see this for a minute. Just give this.
But will Mr. Gehlot not be held accountable for
He
this
can, of course, he should be held accountable.
thousands?
I am saying so.
Not anymore.
I am saying so. No, let me be upfront. Please hold him accountable. Let's not mince words. But this is not fair. Just see what is happening.
That's
You
the
are going to affect India like this. Just give me a minute, brothers. I'm sorry. This is a more recent thing. The first para starts with the Prime Minister's statement. Then Malas, all this is given. Just come to Malas para. Come on, nobody concentrate here. Para Malas 5. Para 5. Don't do multiple things.
5.
The two leaders welcome. Now just see para 5.
That's all, it's all.
It's a totally new company. There's no question of Malas. The Prime Minister flagging this company as the single biggest investment unless we have nothing to do with it.
Filing reply on behalf of responsible number 7.
Yes, which has nothing to do with Mr. Gehlot to the party separately, I believe. He's a party separately. Right? He's a party separately.
No, but your entire reply you have filed on behalf of India Bull.
No, well, it's-
So, Lord, India Bulls remains India Bulls. The new name is Samman. This is an investment into India Bulls. So, India Bulls is R7, it will remain R7.
nobody's around of the old. There was a promoter one time. There's no promoter now. Even when we filed the affidavit, this promoter, without promoter company, had 4.5 lakh shareholders. At one time, Mr. Gehlot had about 9-10%. He's out and exited completely. And Manas, on top of BlackRock, which is a very well-known US fund, which had Manas 5.5%, now it is overridden because once 8,000 crores, of which 5,000 crores has already come, then the largest shareholding is the Sovereign Authority of Abu Dhabi. That's why it's changed. My lord is right. At one Manas, historical point long ago. So nobody is saying a lord will not prosecute Mr. Gehlot. Manas.
हमने application.
If it is otherwise said by
not
Mr. Raju.
May I only point out one thing, Mr.
We are for the company in which, Lord, this investment is coming. That's it.
And every time Mr. Bhushan Manas, that link is a little
Yes,
problematic.
yes,
Manas.
yes.
I have no problem with it. He starts with Mr. Gehlot and then yachts and all this. Manas. None of us have seen those yachts in this company.
I must just point
It's
out one
investment.
thing, my lords.
Is there any-
My lord, may I only point out?
Is there any link between them?
That I don't know. I am not aware of any link between Mr. Gehlot
That's
and
the point.
new company which has apparently come in and taken the major shareholding in this company, in this now called Samman Capital.
Arey yaar, no.
That's not the point. The point is,
Please record my statement that Gehlot has no shareholding. Mr. Bhushan will check that out.
I intend to hold these shares and participate in the fund. We did premium include that.
Well, in fact, along with BlackRock, I'm sorry. LIC has
4%, Milord, in this
board
India
member and 4%.
And they have a nominee
Now, of course, the
director.
largest is going to be this Abu Dhabi authority because they have a very large amount of money.
No, 4% in your company now.
4% of this Samman capital
Is held
is held by LIC with a nominee director on the board. 5% at that time was held by BlackRock. Now with 8,000 crores coming in, these percentages will change because apparently that will become 95% or more than that. This- 40, I'm sorry. 40.
Cannot offload his shares of someone.
23.
No, best shares have been issued.
23, we filed an application in the Delhi High Court saying that he should
2020,
not,
let us answer the
he
question.
should not be allowed to sell off his
Please,
shares.
sir, let us answer.
He issued a public statement that he
My
will
lord
not
asked-
sell off his share.
Mr.
And thereafter, my lord, he
Let
sold
me
off
answer
all
a
his
factual
shares.
question. It's 2022.
20. You see, one case is very shocking for us, that whatever is coming private version, the official agencies are sitting silent.
No,
And
no,
that-
I'm sorry, but may I only,
It's a case, clear case of some quid pro quo somewhere.
may I only mention two things, my lord?
Otherwise, after investigation, you can tell us, why should we hold a brief that if there is
Mr.
nothing in
Raju,
this case?
please investigate the role of Gehlot in the
We are
movement of
investigating,
capital
we are
out
investigating.
of India Bulls.
He'll be investigating.
And his subsequent, and if at all, his subsequent role in the treasury.
I'll tell my lords what is the
That's
issue.
all.
You are completely silent on the original.
I'm not silent, my
entity of
investigation is
number
going
seven.
on. My
You are
investigation
talking,
is going
whatever is
on.
coming on record is
No,
about the
but-
new avatar of risk number 7. What about risk number 8 and 7 both?
May I
originally?
only point out two things, my lord? ED flagged 6 issues. 5 issues EOW is investigating. That investigation has not culminated into any report, either final or a charge sheet. They're investigating. Number 2, my lord,
No status
SFI
report will file. That agency doesn't have the guts to, in court number 1, to file in a status report.
I'll
But
file.
what have they done?
Give me 2 weeks' time, I'll file it. But 2, my lord, second,
File that
SFI
direct
now
statement
started
present here
investigation.
in court.
Mr. Raju,
This is the way.
feel EOW is investigating and that is standing in the way of recording an RC. We will direct the investigation to be transferred to.
Let
the
me put,
CBI,
let me put my
because
status
this
report within
will
2 weeks.
have- And across the border.
I'm not saying
duplication of
anything else, but
investigation.
let me file a status report after 2 weeks. My lords may take a decision after 2 weeks. SFI has also started investigation because MCS director.
On an explanation that from last 7 months, what have you done?
I'll put it in my affidavit, my lords.
Say in this case, the conduct of CPI. As well as EOW wing of the Delhi police. Is highly questionable.
My lords may not say that, but I'll tell.
I have to say,
But CBI, as far as the 6 issues flagged by ED is concerned, 5 have gone to EOW. There's nothing to do as far as CBI is concerned.
they have been taking time, it was their duty.
We
their
made an
directors should
application
have
of
filed
court,
an
it is
affidavit, that's
pending in
what
the
they have
court,
done
but
in
there's
the last 7
nothing
years.
as far as CBI is concerned. The CBI is concerned, nothing, but there were 6 issues, 5 issues, EOW is investigating. The other issue was SFI is not investigating, MCS direct SFI is investigating. Those issues which are being investigated by other
The
agencies.
manner in which the CBI and the EOW wing of the Delhi police has responded in this case is not less than shocking. we direct the commission, the Deputy Commissioner of Police, EW of Delhi, and Director CBI to remain present in court.
My lords may not say that, but I'll file an affidavit.
Status reports we also file. Post after 2 weeks on so and so date.
Well, we
There,
have filed
there
an
is one
affidavit of-
IA
My lords
12287
may
to
not
invest.
direct,
my
but
lord.
we'll put an affidavit, my lord.
No, no.
We'll put an, if my lord fails,
Mr.
that,
Raju, last
why if there is something wrong with the affidavit, if my lord fails that nothing has been done, then my lords may pass. I'm not saying this.
they
It may be.
could tell us, they could file a status report, look here, we have taken these steps and initiatives.
Therefore, after my status report, my lords may call.
Drop the matter.
After the status report, my lords may direct, my lord. If my lord fails that nothing has been happened, then my lords may direct, my lord.
Regular crime case. And within 2 weeks, you give a report.
We'll file a report if my lord fails the report.
No, Mr. Raju,
My
we
lord
want
call any
the
officer.
regular
But not
crime
today.
case to be registered.
Not today. My lords will give us.
Our
2 weeks.
earlier order was very clear.
Yes,
There
but
was a
I'm-
complaint by ED, and in the joint meeting between the officials of ED, CBI and SFIO, ED persuaded that there should be action on their complaint. Now, under this explanation that investigation is given to a local investigation agency, you are staying your hands. We would request you, please register a regular crime case.
Unfortunately, I'm.
Don't forget, Mr. Raju, it was CBI, it was ED, who was time and again approaching this court that you please liberate us.
He is
from the
requesting you
investigation.
repeatedly, take action, take action.
Well, my lord, we have taken action. I'll.
When
put it
we
on
were
affidavit.
dealing with Bombay High Court judgment, then these agencies were insisting, no, please allow us, give us
Yes,
free hand
it was
to
my request
hold
that I
an
said to it,
investigation.
my lord.
The
And-
movement is what magic wand has played in between, we can't
Nothing has
understand.
happened, my
That
lord.
conduct is completely unexplainable.
Therefore, my lords may just give me 2 weeks' time. I'll put my affidavit. Thereafter, my lords may direct whosoever to remain present, my lord. Today, I am requesting my lords may not call anybody today, my lord. After 2 weeks, after seeing the status report, if my lords fails that there's something wrong, then
Owing to the fact, owing to the sheer negligence demonstrated by CBI and the Delhi Police EW wing in not even filing a status report and in their total failure to apprise this court about the steps, if any, taken with respect to registration of RC or investigation in furtherance thereto, comma, we would have summoned the heads of the investigating agencies, but for the persuasion made by Shri S.V. Raju and Additional Solicitor of India, who assures that
It will be done in.
that needful will be done without wastage of time and status report shall be filed within 2 weeks.
great.
Post this matter for hearing on so and so date.
I am obliged.
Blush.
Well, it's in 20, we have an application.
Yeah, sorry.
It's dealing with that Air India crash in Ahmedabad. My matter, I'm appearing for the father of the deceased pilot as well as the Federation of Indian Pilots. In item 20.3, it's IA number 214482, my lords. The investigation is still on. But there has been some developments because the investigation is also on. Victims are from the US, from the UK, etc., because it was an international flight. So in the US, my lords, we find that there's a law firm which has done the investigation and found that there are some serious discrepancies which take place with reference to the records in the flight when the flight takes off. They've discovered that what is known as the RAT, it's a ram air turbine. It's a kind of generator that comes on when the flight is about to take off at an emergency situation when there's an electronic cutoff or a hydraulic cutoff or a thrust cutoff. What has happened from their analysis, and they've done 10 simulations. Your lordships know that each kind of aircraft, they will have a simulation on the ground where they just try and test to see what could have possibly happened. The simulations have reflected that while the plane was on the ground, apparently that ram air turbine was deployed, and photographs from the Ahmedabad airport show that that is hanging out from the plane. It comes out as a warning sign even before the plane took off. This is important because it completely disavows then the possibility of any pilot interference. Pilots start operating at a later stage. Now, the reason why this is relevant is they have written the American law firm has written, the Federation of Pilots has written, all of us have written to the DGCA, who is organizing the investigation, leaving the legality of the investigation aside, because we believe it should be independent. The ICAO, which is the charter which we have incorporated, requires it to be completely independent of government agencies. But even otherwise, at least consider these factors is what we have asked for, and we have specifically requested that you carry out the simulation that is required. 10 simulations have been carried out by this foreign firm. In this IA, my lords, your lordships will find that at page 31.
Say something.
Can I just complete, Mr. Mehta? Just 1 minute.
I'm saying something not against you. My lord, I'm aware that the father of the pilot is before us, before your lordships, my lord, and therefore I'll be arguing accordingly, my lord. I cannot take an adversarial stand against the father, my lord. We also, my lord, are equally grieving, my lord, for the loss of such a, my lord, eminent pilot. My lord, my instructions are, and the Director General is present, that the simulator test is also conducted. There are more than 4 simulation tests are already conducted, and it would be a part of the record. So far as, my lord, this law firm is concerned, my lord, I received this, I have not officially received, but this was received from the net, the rejoinder, my lord, where this is placed, the application which was placed on 25th of July 26. So I have not been, my lord, I have given them.
This firm has not communicated this data to
No.
AAI.
No, it has.
They've communicated it. They've communicated to us.
It is coming.
We annexed it in our letter to them.
Mr. Solicitor, ask the agency investigating to take into consideration.
That's all we ask.
Certain.
That's what we ask.
No doubt about
That
it.
has to be considered.
My lord, the Director
Yes.
General of
Civil aviation.
AIB,
AIIB.
yes,
Is the-
AIB must take into consideration.
Certainly,
whatever,
it would.
and make its comments on it.
Certainly.
As to whether
The report
this is
should be-
reliable, not reliable, or even if reliable, why it is.
Report should be
acceptable.
self-speaking and yes.
Actually, my lord, there is one fundamental issue. Under Rule 12 of the Aircraft Accident Investigation Rules, the rule says that where there is a,
We are conscious of it.
yes,
What Mr. Bhushan, we have not decided because they've undertaken this exercise as a non-casualty category, so it can be done by the in-house agency.
no, in
We are
addition,
waiting for the report. If the report satisfies everyone, we don't go into this question.
Yes.
But if there is a dispute, we will definitely
yes, I understand. Now the problem
All of
is
us are
this
conscious
report by an
and
independent.
all of us are, my lord, with the
AIIB
father of the, my lord. There is no doubt about it, my lord. But let us not do something, my lord, which is right now not called for.
in this
No, Mr.
AIIB,
Solicitor, the submissions made by Mr. Gopal and Mr. Bhushan are that in view of the international treaties, the India being a signatory, investigation of this nature requires an independent agency. But because the agency has already commenced investigation and has substantially progressed, we choose not to entertain this debate at this stage. Let us await the result
Okay,
and
Lord,
if
I'll
the report is
respond to that.
satisfactory for all
I think
concerned,
Mr. Gopal's,
then
I
this
understand.
issue open.
Lord,
I
Mr.
know, Lord,
Gopal's,
but what has
Gopal
happened is-
Shankar Narayan's submission, my lord, is fair. And my lord, therefore I have responded. Lord, it is, my lord, Mr. Bhushan takes the court somewhere else, my lord, where I would not like your lordships to go. Let the report come and my lord, we examine. My lord, he is on a judicial inquiry or something.
No, not under the.
And this is an independent inquiry, my lord, in a sense.
His arguments, we are postponing for a later.
Yes, certainly, my
date
lord,
till
we'll
the
deal
report.
with.
actually, my lord, I think what your lordship is saying and feeling is perfectly reasonable, but the problem is this. It's been more than a year since this investigation began. From day one, we had pointed out that in this team which is investigating this, out of 5 people, 3 people are officials of the Directorate General of Civil Aviation, which even the AIIB investigation is supposed to be, there was an earlier committee appointed to go into all this, they had recommended, this should be a permanent body and this should not have officials of this DGCA. Because there is a conflict of interest. The DGCA is.
No, we cannot have trust in everyone. My lord. We
There is-
cannot have not trust. Mr. Bhushan never trusts anyone.
Understand your submissions.
Yes.
As of now, if facing a particular crash.
Yeah, he
Nor
doesn't
are
trust
there
any institution.
bigger implication
Yes.
of future outrages like this or future unfortunate
That have
incidents
already
like
been
this.
actually since.
Let us see, because this agency comprising of, as you allege, of conflict of
Agency
interest
officials.
individuals undertake an investigation, and if the investigation is well merited and accepted, it's an end of chapter for this particular case. Then we can go into the question of future cases, how it's to be handled.
The rule says.
In
that-
the alternative, the report which comes is not satisfactory to Mr. Gopal's client, is not satisfactory to other.
what is
affected
happening,
people.
my lord,
I
as-
can say,
Then we
Lord,
can-
let me.
What
let
is
me make it
happening
clear,
is-
Lord, these are only for some other, Lord, consumption at elsewhere. Lord, as a matter of fact, I have already pointed out and I have said in my affidavit, my lord, that it is not this committee only. They may not be members of the committee, but under the, my lord, international protocol, we are supposed to have experts of each country whose passengers also unfortunately died.
Right.
So they are also involved. So it's not, my lord, that our in-house, a kind of an investigation is taking place.
That is why we are postponing this
Yes, sir.
allegation of bias or incapacity.
My lord, please don't
Till
even
the report
consider,
comes.
he has an idea of bias against every institution of this country. So that can never be a ground. Please consider the report, and thereafter, if your lordship find,
That is what.
yes, my lord, that's all.
In January, my lord, they stated before the court.
Wait, Mr. Solicitor, now you should have at least an interim report.
My lord, what
They
I have.
stated
I
in
have-
January that in 3 weeks, the final report will come. They told your lordship this in January. Now we are in July, end of July.
My lord, what has happened is,
Wrap up.
my lord, every component or every part of, my lord, these aircraft, wherever it is manufactured, it is sent there. That's the international protocol. We cannot do anything. My lord, we are expecting in, my lord, middle of September, the final report will be out. But we are, for the sake of, my lord, just to keep a buffer, saying that by the end of October.
End of it.
Yes, my lord, I have said on affidavit. I have said on affidavit, my lord.
Order on this IA that he.
Manoj, I have two small submissions. Manoj, I have two small submissions, just a minute. 11th February 26 order says that the report will come in a sealed cover. I suggest that that may be a direction, that whatever this final report is, we don't want to see it in the press. We don't want to have to deal with that. So please have that. Now, the matter is before the court and the learned solicitor says September, even October, whatever. Let it come in a sealed cover here, one. Two, the second petitioner is the Federation of Indian Pilots. It's a federation of all the pilots of all the various airlines. If one suggestion that I have is if they can call on us, we have all the data, we are all the experts, we have every report, even internationally and from India, on this particular airline and this particular airplane and the previous incidents that's happened with the airplane, just to satisfy ourselves that we can place it before
We have
that
all the report,
investigating authority.
the records.
Yes.
And as per the protocol, my lord, we will be breaching international protocol if we take that.
There's no breach. It's an investigating authority under the rules which can get source material from anywhere. So if he's saying that there is a breach, there is no breach, both under ICAO as well as the aircraft rules earlier and the rules which came out in 2025. There is no breach.
Mr. Solicitor. Further input from. Mr. Solicitor, without going into the question of breach, whatever data they have,
My lord, let me,
them place it before the agency.
My lord,
It would be up to the agency to take the data.
let
or-
me, my lord,
Of
take
course.
instructions and I'll respond. My lord, in a matter of this nature,
No, you.
I will not take,
let
my lord,
me clarity.
because I always take, my lord, things with.
Since the director is there, the instructions can be given now. He's standing here.
That is for me and my client to decide, not for anybody else to decide. Where I would take instructions, how, but that is for me.
You're the one who mentioned he's here.
Yes.
Unnecessary then.
Wonder that whether we are judges or referees in a box.
My lord, sometimes.
Some people do it for
reason
publicity.
To your disadvantage.
Hmm.
Therefore, my lord, I am little careful.
You no fear of that
Yes.
from you. How many emails?
Rule says that a major catastrophic accident involving fatalities will be formally investigated by a court of inquiry. And the Rule 12
That's where it is
says,
leading to, my lord, ultimately.
the Rule 12 says that in addition to AIB investigation, there can be a court of inquiry.
But this argument you had advanced at the first day.
First day.
Yes.
We have not rejected your argument.
I know.
Just postponed the decision on it,
Just to see the
awaiting
outcome of-
AIB report.
I
And
know,
ultimately,
Lord,
he would
but
say the court of
every
inquiry was
delay-
also worthless and not trustworthy.
We are trying to be constructive here. I'm just giving a suggestion. You have an expert of Federation of Indian Pilots. We have lost two of our own.
Mr. Gopal, yes,
We have sent 6 emails. There's been no response.
like to take instruction and. then
That of course,
pass the
that he is entitled to take instruction.
He is entitled
No,
to.
they
Oh,
have
that of course,
instructions given.
that of course.
I don't wish to, my lord, join issue. I will remain, my lord, my mind alive of the fact that I'm dealing with father of a departed soul.
And
I'll not respond in any
number
other
of
manner.
independent experts had said that there appears to be a catastrophic system.
7482 of 2026, inter alia, saying that responder 3 be directed to conduct simulator tests to verify the timing and sequence of events.
Them give. Officially, they can give, my lord.
That's very fair.
By the father or, my lord, the association may write.
Federation, petitioner too.
May write.
That's very fair. I'm grateful.
Crash of Air India Boeing 787-8 Dreamliner aircraft on 12th June 2025 at Ahmedabad. The Learned Solicitors of India the further claims that the results of such simulator testing be placed before the court for the final.
Lord, one more thing, but I'm feeling little, Lord, perturbed about it. The projection is that something is happening behind the closed doors without taking us in confidence.
No.
Our material is also not being taken.
It's not a-
They were invited in the meeting, my lord, and everything they wanted to give is taken. My lord, the Director General is here.
Who's,
Please do not, let us not, my lord, we are dealing with a very, very, Lord,
By way of abundant caution, we are giving this.
please do that, my lord. Otherwise, my lord, nobody would ignore the Pilots Federation. They were invited, they have.
no,
come,
there's
they have
nothing on
participated.
record. I've been told my instructions are 6 emails were sent over a 6-month period,
All
no
were
response.
replied and your clients participated in the meeting.
Purpose is to put your.
No, absolutely. So let's not get into this to and fro, my lord.
That.
No, I don't want to go into that. That's what I'm saying. I mean, he's very
Go
fairly
into it,
said that
Therefore, I had to
his-
respond.
instructions are that.
On instruction from the officers, including the Director General who are present in.
No,
States that simulator tests have been conducted and thus the issue raised in this IA has already been responded. As regard to the petitioner's prayer that the Federation of Indian Pilots be also associated in the ongoing inquiry. We are informed on instructions that the
Associating, nobody can be associated.
No, we don't want to be associated.
No, even if you want, that's
that
not
the
permitted.
I'm not
that may be given by the Federation will also be duly taken into consideration in the process of inquiry. Learned solicitors are further informed that the final report is
Association was
likely to
also
be
invited to give their inputs earlier.
Yes, agreed.
I'm denying that, so it's best that neither side is recorded on that.
Right. Let denial be recorded.
Mission.
Yes,
Let denial be also recorded.
my submission may also be recorded.
Yes, please do that.
The final report is likely to be submitted in the first week of October,
Nothing.
by the first week of.
Let him-
Address this matter for further consideration also.
Look at that.
List it on October, on 13th October,
Yes, sir.
on 1.
Well, the report will remain in a sealed cover.
Yes, yes.
I'm okay.
Because if your lordship doesn't say that in the order, then,
No, no, it will remain in the. same-
very well, his assurance is enough.
Come before your lordship.
Very well, I'm grateful.
That's in item number 21. The gentleman has passed away.
Yes, yes.
So it's become an academic question now because
Is
the
there
question
anything surviving in this?
nothing, because he's passed
He's
away.
passed away and further elections have also happened.
Further elections are also.
We are concerned for the petition state that after the unfortunate demise of Hon'ble Court, Hon'ble Roy, nothing survives in this petition. For this is called the Judicial Services.
I'm grateful.
Grateful, madam.
Please, my lords. Well, in item 22, though reply has been filed by respondent number 2, Union of India through the Consumer Forum Ministry, but not by the Ministry of Health and Family Welfare and the National Medical Council. Well, I'd like to file the rejoinder affidavit. In the meantime, there are certain intervention applications also.
Yes, my lords,
which have come.
yes, my lords, I beg to appear.
How much time you want to do?
My lord, I'll file 4 weeks, the reply affidavit, rejoinder affidavit, but let the Union of India Ministry of Health and this National Medical Council also give their reply. They have not given their reply as yet.
Another 4 weeks.
Your lordship,
4
one
weeks
person
time.
may speak.
My consumer
It's
department,
only through the
R2 is
Ministry
filed.
of Consumer Affairs,
R2
not
is
the
filed.
Ministry of Health Affairs.
The office report says R1 is not served, but you can take notice.
When
that
will that
R1
file?
Union of India Ministry of
It
Health
says
and
remarks,
Family Welfare.
no such person in the address.
Your Honor, I am Dr. Rajiv Joshi, appearing from Medical Legal
When you
Society of
want
India.
to file Inspector of Consumer Affairs, they have filed. Ministry of Consumer Affairs.
Filed health as. And
So the counter affidavit if any by the Ministry of Health may also be filed.
And the National Medical
Your
Council.
Honor,
My lords,
I have
I am
not taken
appearing
the
for
report.
National Medical Council. National Medical Council. I am appearing, Commission.
file your response.
Yes, my lord, need 4 weeks.
You are one of the most
Yes,
important
my lord.
regulators.
Yes, my lords. Need 4
His
weeks.
lordship's
time.
kind
My lords,
permission,
I
may I
have-
speak?
I
I'm
have-
Dr. Joshi from Medical Legal Society of India. We have filed intervention application, but it has not been taken on the recording cause list.
Yes,
Yes, my lords, I have. My lords, I beg to submit, my lords. I have moved an intervention application, IA number 1012245 of 2026 at serial number 2 of the office report, my lords. This is an application moved by the Indian Orthopedic Association, my lords, which comprises of about 17,000 doctors, my lords. We join issue with the petitioner in the matter, my lords. My application may please be, notice may be issued, my lords, so that we may be.
There are 8
My
interventions.
lords, I
Yes,
appear for
yes.
the Indian Medical
Voicing,
Association. My lords, we have also
There
moved an
concerns both
application.
sides.
My lords, it was on the Indian Medical Association's rate that the
Are you
earlier
allowed?
judgment in VP Shanta was passed.
Correspondent, number so and so. We newly added respondent may also file. Dr. Joshi, you may file your reply.
We have
My
filed.
lords, the
Your Honor,
IA, my lords, the
filed a
IA at serial number 1 of the office report may also be considered. My lords, I appear for the Indian Medical Association. We had, my lords, filed the earlier writ petition in which the VP Shanta judgment was passed,
Just a
which is
minute,
now direct.
Just a minute, wait for it. That Dr. Joshi is already talking.
Please, my lords.
97243 of 2026, the IA number is there. We have filed the IA, but it is not on the list of the cause list. Kindly permit us to file a reply.
Where is your IA number? We can't understand.
97243.
97243, but it's not on the cause list.
Yeah, it's not in the list.
It's not on the cause list.
In fact, there are 8 IAs which are not in the cause list, sir.
There are only 6 today, but otherwise there are 8.
There is no IA by, the number you are giving it is listed today.
My lords, in the
We
office
have filed
report,
it already. First IA filed in this case, Your Honor.
office report mentions the IA, my lords.
That's of IA number so and so. And listed on the next date of hearing, subject to hearing of the facts and findings.
My lords, I've also filed an IA. My lords, I've also filed an IA, which is listed in number 3 of the office report today. Notice may also be issued in that manner. I filed on behalf of Voice Society. I am joining with the respondents.
No, you want to become party too.
I am about to become party.
What is the number of your IA?
Listed on
Society is 118161.
118161, my lord.
Serial number 3 of the office.
Serial number 3 of the.
What is your problem? Why do you want to be party?
Intervention.
My lord, we want to join cause with the respondents. We want to join cause with the respondents. My lord. Yes, my lord.
Intervener or impediment?
Intervene.
So why is it allowed to?
My lords, the IA at serial number 1 of the office report, my lords, may also be considered, my lords, for Indian Medical Association. That is IA 101989, my lords.
Respondent is granted 4 weeks time to file the contract with the firm. But issue IA to verify. Yes, next up. When did memo parties need to be filed?
Yes, my lords, we'll handle.
I have also filed one IA for impletement lordship. That may also be considered lordship.
Hand over copy.
Obliged.
My lords, the amicus status report is.
We had a.
We are seeking certain directions, my lords, but that may require some time for my
Mike,
lords.
Mike.
The amicus status report is filed. We are seeking, I have suggested that some directions may be passed by this honorable court, but the same may require some time for my lords to consider, because those are primarily for some directions on how the digital arrest victims' matters may be decided by the concerned courts, forums, because some matters are going before consumer courts. Some are going before the adjudicating officer, where now it appears from the government status report, a special process has been established. Otherwise, under Section 46, the Secretary Ministry of IT was the adjudicating officer, and they were dealing with some of the cases. But there is some disparity in terms of how it is being approached. Therefore, I've sought for some directions from this honorable court with respect to that. The second aspect which I have sought for is for the status report, because the last status report was filed before the courts closed for the summer vacation. And that a short status report was received by me today, my lords, on that. The second aspect is with respect to the jurisdictional issues. Now, the issue is with respect to consumer courts, where cases have been filed with respect to the payee bank also. The customer is not a customer of the payee bank, but monies have been siphoned out using those multiple payee banks. The issue, therefore, that seems to have arisen, and where, therefore, the digital arrest cases are still pending for a decision, is on whether payee banks can also be prosecuted by consumers. Payer bank, they will have a claim against, but payee banks are something that's still pending. Therefore, there on the jurisdictional aspect, some clarity from this honorable court may be critical. Again, one aspect which this court has already passed certain orders in with respect to freezing of bank accounts till of proceeds of crime alone and till disbursement. There seems to be, again, still continued inconsistent orders arising from different high courts. That may have to be evaluated, my lords. Finally, the RBIs and intermediaries are the two issues that I have sought certain directions for. The first stage is where the call comes in, and after a general call, it becomes an audio-video call, and now mostly WhatsApp is being utilized. So apart from WhatsApp, there are other chat apps like Telegram or Signal. Therefore, it is not only with respect to WhatsApp, but any of these chat apps, if they are going to be utilized, if there is a kill switch, after a reasonable period of time, it doesn't have to be 1 or 2 hours. WhatsApp's IA appears to indicate that, but that is incorrect. What has been suggested is AI can be utilized to evaluate what is the timeline that should be mandated, and a warning can be first resorted to, a pop-up message in the middle of that call to say that you may be a victim of a scam. Watch out if this is happening. The second stage is an actual kill switch, where it closes the call so that it gives victims pause to see whether what is it that they should do, and also for others to intervene. Now, that aspect, the status of the government's response indicates that they are still evaluating it, and they want to evaluate the feasibility of the same. Technically, there should not be a feasibility issue, but it will have to come as a regulatory process from MeitY, if at all, and it has to be uniform for all chat apps. It cannot be only for one. So that clarity on that is sought. As far as intermediaries are concerned, as far as RBI is concerned, an SOP, a standard operating procedure, has been issued for the payee banks, particularly with respect to the freezing of proceeds of crime and its dispersal. But the suspicious transaction identification and velocity checks that the RBI circulars mandate, but that aspect should be clarified for payer bank also, and that is not yet there in the standard operating procedure. Therefore, we have sought for that one clarification, 2 minutes. This is a short list. If I may just share only the directions that are being sought as a separate document, just for the ease of reference.
We had a pre-court hearing meeting between me and the amicus.
Yeah.
And then we thought we'll sort out certain issues on a common understanding. And I prepared a note before we get a final report from the IDC. The IDC is doing excellent work. And I've been attending 2 or 3 meetings IDC myself. And we had a meeting on 14th of July. Thereafter, I had followed the meeting with the Department of Telecommunications, MeitY, and RBI. So we are in the process of finalizing a reasonable report to identify each and every dot in the system so that we are able to prevent and then prosecute and look at other aspects of the matter. Therefore, I would request the court may hand over a brief note which I have prepared for your lordship consideration on the 3 or 4 broad issues with the learned amicus at flagged. The IDC has been looking into it very closely with all the technical inputs available. May I just request her just look at the note.
Real worry is, learned attorney, despite very, comparatively, very harsh order was passed by us. Lot of wide publicity of the directions have also been.
It has.
But despite that.
No, kindly see this note. Kindly see this note. This note gives an important progress. So after the court's intervention and the IDC is taking charge of many unconnected dots, as I put it like that, this is the current position. So from 1,23,000 last year, now 15,215. So the ability to arrest has been, I think, handled very carefully. Now, at the highest level, the IDC has been asked to look into both the attitudinal issues where people suffer a digital arrest and also the structural issue that have been addressed. Therefore, they're receiving the highest attention. Now, kindly turn to paragraph A. Under A, what are the steps that have been taken? RBI has formulated an SOP prescribing the action of the banks and temporary debit hold and account in order to prevent money mule activities and cyber-enabled frauds. Then MOU between Reserve Bank Innovation Hub and I4C concerning sharing of data for enrichment of the Mule Hunter AI Suspect Registry Framework executed on so and so. Then RBI had public consultation of the following: a discussion paper on delayed transaction safeguard. Consultation process concluded in 8/5 and is presently under examination. Then next, draft instructions and customer protection electronic banking transaction issued to public consultation. Then RBI has gone further, amended directions and review framework of limiting customer liability in digital transaction, issued on 24th and will come into force from 1/1/2027, maybe even earlier, I do not know. Then constitution of a working group under the Interdepartmental Committee, comprising the representatives of the Reserve Bank of India, I4C, banks, and other concerned agencies. The working group will study the root causes and then document the best practices adopted by various banks, identify operational challenges, and then suggest interventions required, facilitate cross-pollination of successful measures, assess emerging trends, and recommend strengthened mechanisms for the detection and prevention of mule accounts. In this regard, I'm asking for a certain direction now. Then CBI set up the ABAI portal for verification of CBI notices. The public users can upload the suspicious notice, verify it, authenticity, and is being used. Then 8, MeitY has set up a portal, adjudication compliance digital system portal for adjudication under Section 46 Information Technology Act, and will provide the timelines for its authorization. In fact, we are asking them to push it as fast as possible. Next, no rules are needed for centralized international outroma so-and-so. Then you'll also look at it in earlier order. Then 10, intermediaries are in the process of implementation of SIM binding and they have to complete this process by December 2026. In fact, WhatsApp had been interacting with IDC over a long period of time. And I see Mr. Kapil Sibal here probably appearing for WhatsApp.
Yeah.
And I would probably advise, and in fact, we had conveyed to the court that IDC is interacting with WhatsApp and other chat apps in a very reasonable and accommodative way. I don't think
That's correct. That's correct.
I don't think we need individual chat apps to be showing their concerns at this point of time. I have advised IDC to give as much deliberation consultation as possible, so that every chat app is considered a reasonable basis.
Yes, we are working very much closely with the government on this, and we'll
So I
collaborate.
don't think the court need to be bothered at this point.
Exactly. I mean, that's what I think.
So I go to then 11 for regulation of SIM boxes, telecommunication radio equipment possessions, and so rules have been notified on 8th of July. These are progress which happened with Lordship's last proceedings in February. Then draft telecommunication rules are in the final stages notification. Time is needed till the end of August 2026. Then telecom service providers have strengthened the point of sale verification framework by incorporating physical verification process, eKYC authentication, and regular audits of subscriber activation system. Then discussions are underway with the Telecom Regulatory Authority of India to strengthen the regulatory framework governing telemarkets and the distributed ledger technology framework so as to prevent the misuse of SMS headers and enterprise messaging services. I had discussion with the Telecom Regulatory Authority, and they're in the process of giving some suggestions in a reasonable point of time. Then the kill switch mechanism's efficacy had not been tested, and accordingly, the government is looking at methods that will warn the user about calls from unknown persons. Then implementation of CNAP so-and-so system where an unknown call is received, the name of the caller according to KYC document is displayed. All this is happening now. Then section 12AA of the PML Act perhaps is not the right provision for suspected transaction. Now kindly turn to, after all that, paragraph 18, Ministry of Home Affairs SOP concerning so-and-so custody and restoration of money and grievance redressal dated 2nd January was circulated to all states, union territories, law enforcement agencies, and registrar generals. And now it's in the process of getting inputs from all of them. Then para 19, the above SOP required establishment of 2 portals, grievance redressal mechanism portal, and then under this mechanism, the grievance of individuals are addressed. Then 1,23,590 branches of major banks have been registered on the GEM portal now for grievance registration redressal purposes. 69 banks are presently participating in the mechanism. All states, union territories have already undergone training for implementation. 146 state level grievance officers also have been nominated. And then over 20,000 agreed persons have already been contacted for banks raising grievances through mechanism. 18,072 grievances have been registered by bank branch in the portal, out of which 9,250 have been actioned by the concerned law enforcement agencies. So then we have the money restoration mechanism portal, facility for returning defrauded money to the genuine victim so-and-so, the single platform for the agreed party banks and police. 57 banks and 36 unities are participating in the mechanism. Data reconciliations is taking place. Then banks have updated restoration amount details of 4,95,111 cases on the MRM portal, and more than 1.69 lakh requests have been raised by the victims and for the restoration process. Now kindly skip that and come to 20, E0 FIR mechanism implemented in 19 states. Under the mechanisms, once a complaint involving a loss beyond a prescribed threshold is received on the National Cybercrime Reporting Portal, an FIR is generated automatically. So these are very important progressive steps that have happened. Now CBI, I found, is investigating about 20 major instances, because in the earlier audio I said 10 crores and above. Therefore, 20 major instances of digital arrests, and the state police authorities are dealing with the remaining complaint. During the course of investigation, I skipped paragraph 6. Now kindly turn to page 5, C. Steps taken by the government to increase institutional capacity. Directions concerning the establishment of regional and state cybercrime coordination centers have already been circulated to all the state union territories, and a framework concept note outlining the structure and operational modalities of S4Cs akin to I4C have been circulated to all sources from the Ministry of Home Affairs, and 14 states have notified their S4C. And MeitY is coordinating with the intermediaries for time-bound compliance with the IT Act and the rules framed thereunder. So I only probably recall before I play the next report, the following direction may be essential. Now, in the light of the above, the following directions are prayed. Direct RBI to formally adopt and implement the SOP prescribing the action of the banks on temporary debit toll and accounts account in order to prevent money mule activities and cyber-enabled frauds. And the same we issued across the country for uniform adoption and implementation. And issue appropriate direction to all states, UTs, law enforcement agencies for expeditious adoption, operationalization of the two modules, namely the grievance reduce and money restoration modules. And for expeditious disposal of matters relating to freezing of bank accounts arising out of cyber-enabled financial fraud, direction be issued to the High Court to ensure that the agreed persons be directed to first avail the facility provided by the grievance redress mechanism, and direction finally to all states to expedite the establishment and operations of state cybercrime coordination centers. For the time being, these four directions probably will suffice. The next report will address all the other issues which are now pending for consideration. Yeah, including some of the grievances the learned amicus had raised. In fact,
The note indicates that different kind of measures have been taken by different agencies. Two things probably need to be addressed. One is that why don't you have one structured organization which act as an apex body? Otherwise, a part is to be operated by CBI, another part by the banks, other third part.
the I4C, that organization which is doing that. Then you'll also remember after the second hearing, we suggested an interdepartmental committee. So the IDC is now the monitoring supervising body to which everything is reported now.
And if one apex agency or body.
It is an is the apex body, IDC, interdepartmental committee.
Some kind of a statutory and legislative force behind that. The second thing, that this digital arrest itself or any related cyber crime, that do you need to define it formally in your penal law?
Some of the penal law already take care of them. They already take care of them.
It's a clear case of extortion. It involves
The Bharatiya
kidnapping.
Nyaya Samhita takes care of that.
It involved robbery, to my mind, and there are ingredients of robbery, dacoity in it, everything is there. But then do you need to define it an independent, standalone offense with a very serious and penal consequences?
In fact, one of the suggestions I've put in the amendment
Before we
submission
reach
is
that
to that
stage-
effect. What would happen is if a specific,
Along with a provision
yes,
that where there is a prima facie evidence found against a suspect, his assets should be freezed immediately.
yes.
Before we reach the stage.
Well,
it's
such
important
a
for us to
provision will
identify.
ensure a deterrent effect also. Because today, often we hear that we did not even know such an offense exists, despite all the awareness programs that are that abound everywhere. Therefore, that's one of the suggestions I put. Just a couple of interventions, if I may, on what the learned AG has submitted. The first thing, as far as the kill switch is concerned, there is something about it not being tested. Now, the issue here is that it is not about testing the technology. It's about testing the efficacy of that as a solution, and that may be kept in mind when the ministry is evaluating it for all chat apps. Today's Hindustan Times talks about a case where the person was he was still a victim of digital arrest. The police find out about it, and initially they go in plain clothes. He talks to the criminal to find out, should I let them in? And he says, no, they are fraudulent cops, so don't let them in. And so he listens to the criminal, but not to the real police. And then it took the society members and some policemen in uniform and the plainclothesmen to finally ask him to come out of the digital arrest. Today's report carries this, my lords. Therefore, the fact that victims need to be protected sometimes against their own actions becomes a reality. Therefore, we are cognizant of the fact that it may require an architectural variation.
Legislative changes are necessary, Mr. Attorney.
What I want to say.
Legislative changes in the Information Technology Act, where you have offenses like hacking, etc., but by impersonation also. But the entire legal architecture was in light of the technology in 2000. Today we have deep fakes. We have other technological tools to be used both for cheating and impersonation, which may require a relook and
I quite see that. But what is the thought process is, let us look at before we raise a case of amendment to the larger, legal framework, let us look at what can be done to arrest at some level.
We fight with the given tools, but we are also requesting you to chisel your.
If you have to straight away jump to
The tools first have to be sharpened and then.
it's not as bleak as that.
Powers we've exercised under Article 142, we cannot define a crime.
I understand that.
The legislature to define it.
Well, it's the second
what I'm trying
aspect
to
is,
convey
substantially, there has been a lot of progress, as the learned AG pointed out, in terms of the preventive and protective measures. But with respect to restorative justice or victim compensation, there is still a huge gap. That may also be addressed, my lord.
That is very,
No,
that is the reason I am indicating that where there is a prima facie evidence,
Yes,
it has to be a reasoned decision.
yeah.
That this is the material on the basis of which a prima facie opinion can be formed with respect to involvement of so and so person. And therefore, is all movable and immovable assets immediately be freezed under the law.
Yes.
No,
There was
Only
a
one thing, my
subcommittee
lord,
formed
only
under
one-
IDC.
Apropos your lordship's, my lord, very apt suggestion about the statutory changes to keep pace. My lord, since I'm working in it, my lord, I'm a part of, my lord, that exercise. There is a draft bill which is coming up, possibly, my lord, in this session, which takes care of this
Very essential.
digital arrest, deepfakes, etc.
What you see is we've changed the Bharatiya Sakshar Adhiniyam. Also contemporaneized to certain extent Nyaya Samhita. But the IT Act remains frozen to 2000.
Yes, yes. It needs to, my lord, advance with time.
Law changes, procedural changes are necessary.
No, what technical people are working on.
Section 79 requires a relook. Because the idea of safe harbor is an illusion when it comes to the intermediaries and the way algorithms promote some information and does not
False
promote
news,
others.
false alarms,
Yes,
etc.
yes. And secondly, is the deep fake to be utilized for criminal activities? That needs to be addressed. There's a gap in the special law.
No, without entrenching upon that.
Look,
Deepfake
recently-
already covered by the IT rules, but perhaps not as much as we would like to.
Don't define
We need to
crime.
travel along this. We need
It's
to
a part
travel
of
along
the
this.
draft
Yes.
amendment.
Also,
It's,
define a crime. The primary legislation has to be amended.
Yes. A recent case is where an AI went rogue.
No,
and
therefore,
it
I
was
would only suggest to the court that the 3 or 4 directions I've solicited in my note is an aid in the advancement of what the IDC is now doing before they give the further reports for that.
Employ a robotic
Yeah.
agent for purpose of committing a crime. We're just looking into a sci-fi situation. Where do you put the actor's rears and where is the men's rear? It's today completely unraveling.
No, somebody impersonated the public servant, impersonated the public servant. Is it-
A drone committing an act of trespass.
the most, on a lighter side, the most funny part or most ironical part is when we open some website, the computer asks us whether you are human or robot. And I have to say that I am human.
Are you a robot? And as Mr. Solicitor, a robot today is machine learned to simulate a human.
That's true.
Yes,
You will get it.
yes, yes, yes.
Wait for some time, the third question will be that, or are you both?
Born a human but became a robot.
To show that you are not a robot.
There is a, yes, captcha or something else.
And then the robot
It's
is
called
whether
captcha,
you have
captcha.
complied with it or not.
Today, Mr. Ruatgi, the robots have been so evolved, they can simulate a human cognitive faculty.
Milord's technology has been there more than 5 years back for circumventing capture. It is only us humans who will have to.
At a mind-boggling speed. And law proverbially was always the tortoise. But all of today it's become a snail.
Yes.
This is the statement that in the number of the richest man in the world.
What?
Musk. Saying that in 2036 onward, they give
Other one.
of money.
I just.
Crypto will take over.
The robot will take over all functions, so you will not have to spend.
Including-
This,
I hope the court doesn't, I hope this court doesn't close down because of that.
Not at all. Judges can.
Addressing non-human.
Non-human.
Milords, on a lighter side, on
There
WhatsApp,
is a case, there is a real life case where some lawyer started a robotic farm where you feed your questions
Yes.
or you feed the facts, it would give you document, it will give you, etc. And the Bar Association in some state of USA filed a suit that this is not licensed by the respectable counterpart of the bar.
Regulatory body does not have its
Yeah,
control over.
it cannot practice as a lawyer.
No, but some jurisdictions prefer it actually because there's no bias in the decision making.
but the bias
No,
is
no,
when
no
the AI is built
jurisdiction
itself.
in right frame of mind
No,
prefer.
no, I agree, but I'm just saying there are jurisdictions which are looking at that.
Jurisdiction,
Milords?
adjudication is.
This matter tomorrow, directions are required to be issued. You
Yes.
will also create some directions when you're running. And,
No, what I would
Mike-
suggest is the amicus directions probably should wait for a while because these directions will largely comprehend them. I don't want the
Certainly, we
conflicting
will
sets of
overlap the
directions.
two directions.
Yeah, I mean, I need,
Amicus has made certain concerns about grievance redressal and refund,
no, certain,
which
for
is
instance,
also a part of your prayer A. We merge those.
yeah, I'm little slow on this course now, kill switch. It has some technical issues, therefore let's go a little slow on that. I mean, without.
Milords, we are also.
Whereas
But they should.
Hello.
No killing of the kill switch.
Whereas we have moved an intervention application on behalf of WhatsApp, which is 167,477, that may be allowed.
Milords, that.
So that we can collaborate.
Because there are factual
You
incorrect
can follow a
statements in
reply.
that. Because their entire IA is predicated on this assumption that I have suggested a kill switch within 1 or 2 hours, which is incorrect. 2 subsequent meetings were held, which has not been adverted
It
to.
is good to have the intermediaries on board.
That's right, so that we can collaborate. Malad.
No, if an intermediary is to be before this honorable court, then all of them should be given an
No,
opportunity.
I don't.
Whoever wants to
It
come.
cannot be just one,
Oh,
and therefore.
Whereas she is seeking a direction against us, which is why.
That
Issue notice to other intermediate.
Hello.
No, but she is seeking a direction against us, which is why we have otherwise we wouldn't have intervened.
I have not got any direction against them specifically. I've said
Kill
clearly.
switch applies to us.
Any chat app.
Kill switch applies to us, no?
It would apply to
I
you
think,
also.
That's right, so you're
it's
seeking
better the
that.
IDC handle the interactions with the chat
But
app.
then they should
and
have
then
come out
brings a
with the
proposal
full
which is
information. They should not
the
have
court.
suppressed
Instead of
information.
individual platform,
Your client.
Mention it.
for a lordship.
I have.
You
That will
reply.
make it unwieldy.
So what next, suppose if we can issue directions in chamber also, to sit in a special bench now.
Your lordship, please.
So if, all you want is to. Can we issue
No,
direction?
the IDs, there's going to be another meeting of IDC in a couple of days' time. So probably they'll give a report, next set of report. So that could be sometime in 18th August, sometime. Before that, these directions can go so that RBI can proceed further. The set of directions I have enlisted here.
Let the report come then, and then directions can be issued.
For some time.
And intervention may be
But
allowed.
I'm for RBI, we have no objection if that SOP is
Which one?
ordered to be issued.
That is the next report.
We have to, my lord, in furtherance
Do
of.
that. Take the mic, otherwise.
Intervention on behalf of a digitally arrested senior citizen, my lordship, and 135200. My lordship may allow intervention to assist.
Your lordships have earlier said that no intervention application. It makes the hearing of this away from the main focus.
Application create lot of problem. Tomorrow we'll see what is to be done.
Lords, before your lordships rise, I want to make one, my lord, I have requested Mr. Gopal Shankar Narayan to be here. My lord, in that air crash matter, he was right. There are 2 federations. One came and we had a meeting, not the federation he represents. It's my duty, my lord, to clarify.
So like, we have not mentioned any meeting. We have simply said that if
It would be considered. my lord.
their input will also be taken.
Certainly, it would be considered.
So on our intervention, will your lordship decide tomorrow or?
That incident with yours, we are allowing.
Deeply
We
obliged.
will issue notice to other intermediaries.
They want.
May I suggest this?
Give the list.
May I suggest this?
Deeply obliged.
Issue notice to them.
The Chief Justice.
Them are being heard, then it
That's all
makes.
No, if you if
Several
your lordship allow one chat app to come, everybody will be here. That's why we said IDC should address this problem. Chat apps can go before IDC. It can have the discussion dispassionately. Otherwise, it will be difficult for the court. I wish.
Actually, we are fine with that, as long as IDC examines it, Malad,
Yeah, I
there's no
think
problem.
IDC should take
Before
care
a
of it.
decision is taken.
Instead of applications.
Keep it pending,
the
Malad, don't allow it yet, let the IDC examine it, and if necessary, your lordships may allow it. I don't, it's a technical issue, Malad. Yes.
All right, we'll do that. We'll pass an order tomorrow.
Deeply obliged.
Item 24, any urgency?
Tomorrow, the kind of permission.
But it matters a bit. The issue is interpretation of condonation of delay under section 42 of the AMLA, read with the High Court rules. If my lord has a look at section 42.
Trying to condone delay.
Yes, my delay, no, it is filed within the condonable period. It is filed, the appeal has to be filed within 60 days. We did not file it within 60 days. We filed it after 38 days, but within the condonable period, we filed it.
Your case is delay can't be condoned.
Sorry, my lord.
Your case is that
Yes,
delay.
my lord, it can't be condoned, and there is a recent judgment of Justice Dipankar Datta also, my lord, which also holds, my lord.
That is beyond 120 days. Mine is after 60 days, but not beyond 120 days.
Take up on some date.
In 24.1, may I be permitted to move a substituted service application, Manoj? In 24.1, there are certain respondents who are unserved. May I be permitted to move an application for substituted service on the unserved respondent? I'm obliged.
Permission is granted to answer respondent through substituted service.
I'm obliged.
Lordship,
Item 25.
Item 25, I appear for.
So there's no urgency since your lordships.
Well, it's just that.
Come up next week.
Well, let's keep it on a fixed date. Well, it's a housing society, but the
Next week,
buildings are in
okay.
a dilapidated condition. Well, let's fill here. Well, it's much.
Is also arguing.
My suggestion was that let the applicants, etc., argue first, because they file reviews and applications, and I'll give my points at the end.
Lordship, may I? Lordship, before starting the deliberation with these issues, I have one request. Lordship, I am appealing for Maharashtra Public Service Commission because Lordship, that order dated 13/3. On that day, we have already published the advertisement for 286 posts of Civil Judge Junior Division. And Lordship, we have allowed all the disabled PWBD persons because what happens, sir, there is no, Lordship, the rules.
Right, that whatever change is made that you.
Yeah, we made, but my anxiety is that because of that interim order continuation by Lordship, we are not able to hold the examination.
Madam, we are aware of that because of our interim order. Now all selection processes have been stalled.
Yes.
That we are aware of it.
Yes, Lordship. So I'm seeking some direction because Lordship, thousands vacancies are there.
You are not an exception on the earth. You will follow whatever happened in India.
Lordship, my contention, whatever orders Lordships gave, we will follow that. But right now, let us continue with the.
That the law will be different for you.
No, of course, no, Lordship will follow that. But right now, let us proceed with our recruitment process. That is what my contention.
For the main matter.
Okay, Lordship, please, Lordship.
Your Lordships, we have compiled some suggestions. If your Lordships allow me, I can pass over the suggestions in the written submissions form, your Lordships. We have also filed it on recorders.
No, you please give your suggestions.
Yes.
No difficulty. We will surely we require those suggestions. All of you can give suggestions.
Sure. Your Lordships, we have given it in the form of a written submission, your Lordships. It's on record also, your Lordships.
Madam, Pinky and.
Your Lordships, allow me.
Let's basically, because we have put up lots of suggestions. Hand it over. Let's very briefly, let's adopt what we are adopting for purposes of Group A officers in the government. The Lal Bahadur Shastri Mills itself academy, which, not that I'm saying use the academy, your Lordship, any National Academy or otherwise, but to have a curated program at two levels. One, before Millards, at the time of legal education, Millards, to have a 6-month or 1 year Millards curated program for training. And second, Millards, to have a curated program after Millards appointment in accordance with what is done with the Group A officers. Millards, let me put it, that's a nutshell suggestion that we have. For the reason, Millards, that otherwise Millards discrimination is writ large against women, against people who live in outside places, Millards, against people who have invested, Millards, substantial time and money. And Millards, the delay in the system, which means that the entire margin, Millards, of getting their promotions, etc., Millards, they will become roughly about 41 or odd, Millards, before they come to any higher judicial positions, Millards, which means, Millards, we are putting an end, Millards, and to this entire atrophy to the system. So, Millards, these in essence, Millards, are my suggestions that I can put forth, Millards, which I have put forth in writing from page 10, Millards, onwards of the note. Practice experience requirement may be incorporated as part of the training curriculum of selected candidates in the same fashion as the training given to selected IAS candidates at Lal Bahadur Shastri National Academy of Administration, Mussoorie. Proposal is to have post-selection curated exposure that ensures quality education and mentorship to the selected candidates. This practice experience may be structured in the following manner. These are the suggestions. Selected candidates undergoing training for Civil Judge Junior Division may be attached with district judges for practical training as an apprentice / law clerk / judge in training. In fact, the Center for Research and Planning, Millards, your Lordship's Center, Millards, has come out with this report recommending the introduction of LCRA in district judiciary to further strengthen administration of justice at the subordinate level. It is recommended that selected candidates be attached to the district judiciary and or the High Court with remuneration as a law clerk for their training in administration of justice, legal reasoning, conduct, ethics, and enhancement of legal proficiency. At the same time, it is also necessary to examine the law clerk system and provide for a model structure to be adopted by high courts and district courts on role, remuneration, perks, confidentiality, conflict of interest, ethics, terms of office, etc. uniformly across high courts. The report itself we have annexed in the compilation. Selected candidates undergoing training for civil judge may be attached with designated senior counsels, government pleaders, advocate general, standing counsels, chambers, assistant legal aid defense counsel under the LADC scheme 2022 for a specific period. Now, the similar system has been adopted by Germany, wherein to qualify for judicial office, a candidate must complete a university degree, followed by preparatory training under Section 5B of the German Judiciary Act 1972. Under the said provision, preparatory training is for 2 years in a court of ordinary jurisdiction in civil matters at a public prosecutor's office or at a court with jurisdiction in criminal matters at an administrative authority with a lawyer. And then there are elective training modules available for aspirants looking to specialize. The Act further provides an option to extended part-time training to persons who are caring for or providing nursing care to at least one child under the age of 18 years or a spouse, life partner, or person related who per a medical certificate requires nursing. Because at present, we have separate state judicial academies, because undertaking these training processes, because different induction systems, etc. To have a uniform kind of system, therefore, to have it by the National Judicial Academy or by a permanent committee headed by the Honorable the Chief Justice of India as an ex officio chairman to continuously adopt and develop training modalities to perfect the lower judiciary. Certain changes we suggested in 5.1.2 in the university educational system. In brief, optional structured 6-month practice experience modules during the 3-year or the 5-year law degree as the case may be. Special degree courses designed for aspirants at the college level itself to identify, train and expose aspirants to high quality training fit for purpose, which reference is one of that MNLU BA LLB program for adjudication and justicing. It's very imperative that we flag this as an issue, because once we do that, it becomes a line by itself, which takes itself all the way upwards. Then on the final count, the merit, competence and ability of a civil judge is concerned to both the bar and the bench. It is humbly submitted that this court may continue to see this, therefore provide incentive of scholarships and administrative leaves to civil judges, junior division, to pursue higher education in law and specialities domestically and abroad, provide opportunities, exchange programs, placements and deputations, and finally, continuous education and training, including by way of virtual training throughout the career. It cannot be at the first threshold only, because we continue and we are doing that process, because judicial academies are doing it. If we put it into a structure, that structure comes into a reality, and if your lordship could consider, the office of the Chief Justice. I am not saying any individual, I am saying only the...
Throughout world, training continues even after joining profession.
Yes.
In India only there is this problem that you get a license and then you...
That's right, Milords. It should be for lawyers also. I would say this also. This is engagement we are doing. We are doing at different levels, but they are mostly at the unorganized levels. So therefore, a consideration of whether we could put this into a program, so that it becomes a necessary part of our existence, and a continuity and post-selection as far as judges are concerned. If they wait, their careers are over. They will not take up these lines. You will not have good people coming into the profession. You will not have women being able to come. Your lordship has already considered that at an earlier stage. Disabled and all, is yet another category which your lordship has to look at. The investment which has been put into this entire process and not money. The investment I'm talking about is human energy, which has been put in. It cannot await, another 3 years prior to your appointment. There's no reason why the appointment. The only thing, that the judgment, considers is, an issue of what the high courts consider, is non-effective appearance, or the consideration of the judges. If that is to be addressed, that can be addressed at an educational and a training level. That doesn't require them to be held off for 3 years only for this purpose. That's a continuing process. Yes, we have to consider that. I'm not saying we don't have to, by all means. But for that purpose, you can't hold them off pre-appointment. Have their appointment, hold them off. Hold them off for a year. Have that proper training through a proper process. If Germany does it, I'm not on Germany alone, we're India. But nonetheless, we require systems to ensure that we bring the best forward, and at the right age. Your lordships are constantly looking at the best judges, and appointments are being made for that, at an age, where they will deliver and then continue on, to deliver the same, That is the only objective of this entire exercise,
Lordships, may I add?
My lord, in 301.2, and my lord, I have a submission which, my lord, is dated 13/4/26. I want to bring to your lordship's opinion or attention, my lord. Some things that your lordships may not have. I'll tell you quickly.
Take mic, Mr. Collins, and...
Yes, my lord.
Mike.
Yeah, I've got the mic. So from page 1 onwards, are the Law Commission reports, all of them against the 3-year rule. So that's page 1, page 2, turn to page 3, my lord.
What is the ultimate suggestion?
The suggestion ultimately is centralized training, extensive training of judges, take them in after graduation and do extensive training for them for 3 years or 2 years, whatever. But they are a judge when they go for training. Then, my lord, page 3 is the All India Judges case, 2002. Again, my lord, on the same point. Now, my lord, go to page 4 from the bottom of page 4. That is the 1993 All India Judges case. It was of the opinion, page 5, top of the page, that 3 years standing at the bar as the minimum qualification for entering into judicial service was unnecessary. So then, my lord, at that stage, they took the views of the high courts, they took the views of jurists, and my lord, at page 6, the high court's opinion is taken. High court after high court saying that it is not necessary to have this 3-year rule. That goes on to page 7, page 8. Now, my lord, page 9 is the expansion of judicial academies, so that, my lord, in 2026, this your lordship knows, but I'll just quickly say, at page 10, bottom of the page, almost all the states except a few small-sized states have full-fledged state judicial academies. So, my lord, the time is ripe, actually, at a time when it is ripe to do training of judges whom you take in after, my lord, the NLUs, they pass out from the NLUs. At this very time, my lord, we are sending them back into 3 years of litigation. Then, my lord, page 11 is the article by the retired director of the National Judicial Academy, suggesting in the middle of that page, para 13, that the 3-year practice requirement may be replaced with a mandatory intensive induction training program, etc. Now, my lord, the other aspect is judicial education in collaboration with universities. So, my lord, at the bottom of page 11 is, my lord, the American example of the University of Virginia. But if you turn to page 12, again and again, my lord, repeated recommendations are made that the Judicial Academy should collaborate with universities across the country. Bottom of page 12, my lord, is the French model. Now, my lord, page 13. The suggestion made here is, my lord,
Basically, you have compiled
the suggestions of
the opinion of all the law universities.
Yes, well, but there are some things that are interesting because it was missing in the learned amicus's presentation. So experimental learning, judges who are taken from day one through legal aid, clerkship and internship-based models, continuous evaluation and accountable mechanisms, holistic and evolving judicial training. At the bottom of page 14, my lord, I give you the status as far as the NLUs are concerned. What did they tell your lordship? Because I think the presentation of the learned amicus may not have been comprehensive. Turn the page, my lord, page 15, 16. There seems to be very emphatic interventions by the NLUIs and the leading law colleges, my lord. That's at page 15, 16, 17, 18, 19, 20, right up to, my lord, page 24. No, past that, my lord. 26, Jodhpur, right across the country, my lord. The NLUI seem to be telling your lordship that you should not have the 3-year rule. This is, my lord, right up to page almost the end, yes. But I want to show your lordship something more. Give me a second. Now, my lord, look at now, my lord, page 35. This is, my lord, about vacancies. That when the examinations are held for the higher judicial services, there are a significant number of vacancies in the country. So your lordships are having a sort of a problem filling the vacancies for judges. Now, if you turn the page, my lord. Page, my lord, 35, 36. Top of the page, only 20% of the graduates from NLUI are entering law practice. Apparently, the experience of the national law universities is that if you have the 3-year rule, very few of the graduates from the leading law colleges would be inclined to go for judicial service. 36, the first paragraph, my lord, is a speech by Chief Justice Ramana, there's one. I find that very few students who graduate from the national law schools are interested in joining litigation.
Can you page 37, probably you are trying to point out that there is a conflict of opinion, and then your suggestions are at page 38 and 39.
Yes, well, but one last thing, Ms. The bench, the judgment of the previous bench was 3-judge. The previous bench is also 3-judge. It reverses the earlier judgment completely. And how was it done, my lord, without a reference to a larger bench? 3-judge reversing 3-judge. Maybe right, maybe wrong. We don't know, my lord, but it reverses it totally without constituting a larger bench.
Mr. Raghav, do you want to add something more to your suggestions?
Your lordships, if your lordships have my written submissions, your lordships, my learn in front for your lordships, read out for your lordships.
Plus, I want to add one thing, plus one.
Thank you. Your lordships, Roman number 6, your lordships.
Yes, we have a copy of your suggestions.
Your lordships. So Roman number 6 till Roman number 9, your lordships. So these are the brief suggestions that we have placed on record, your lordships. Your lordships, maybe.
The Lordship proposed phased implementation framework that it is respectfully submitted that a phased and time-bound transition mechanism is essential to ensure institutional stability and fairness to aspirants. Transitional cooling period up to 2029. That this Honorable Court may consider prescribing a cooling period till 2029, during which the 3-year requirement is kept in abeyance. Alternative experimental pathways are recognized. Judicial training infrastructure is strengthened. Phase 1 up to 2029, institutional preparation. That during this phase, a post-selection training program may be expanded. Legal aid-based experiential training may be introduced. Law clerkship at the district judiciary level may be institutionalized. Phase 2 from 2029 post-selection legal aid training. That from 2029 onwards, selected candidates may undergo mandatory legal aid-based training, including engagement with legal services authorities, mediation and grassroots justice delivery systems. Phase 3 from 2030 onwards, integration with legal education. That from 2030 onwards, the final year of LLB, BLLB, 3-year or 5-year, may include a structured 1-year internship comprising 6 months at the district court, 6 months at the high court. This would institutionalize early exposure and reduce reliance on post-degree litigation practice. Phase 4 from 2031, pre-selection practice requirement. A pre-selection mandatory practice model may be introduced. Candidates may undergo structured practice prior to selection. The scope of practice may include litigation, drafting, advisory, and legal aid work. Law clerkship model at the lower judiciary. That a nationwide system of law clerkship at the district judiciary level may be introduced. That such clerkship would provide a direct exposure to judicial functioning, strengthen institutional capacity. Serve as an alternative experiential pathway. Alternative framework if the phase model is not accepted. That, do you want me to do this? Yes. That without prejudice, a 2-year composite model may be adopted. 1-year post-selection training. that mandatory judicial academy training with structured modules and supervised attachments, 1 year structured mandatory internship integration with legal education, that the final year of LLB, BA, LLB, 3-year or 5-year may include a structured 1-year internship comprising 6 months at the district court and 6 months at the high courts. Special provisions for persons with disability, that it is respectfully submitted that persons with disability may be required to undergo only 1 year of mandatory practice, preferably post-selection. Such requirement may continue only until accessible judicial infrastructure is fully operational. Alternative pathways such as clerkship and research roles may be recognized, that it is further submitted that that reasonable accommodation, accessible physical and digital infrastructure must be ensured as a precondition to enforcing any rigid eligibility requirement.
Lordship,
may I submit? Lordship, I appear for.
I just have one addition, before. Public employment and the Indian classical dream. The only public engagement that is available in legal practice is not this engagement at the judicial level and the appointment. And therefore, to perpetuate that situation and to, if take it away by putting in a 3-year gap, is something which would impede the entire course of justice and the judicial delivery system, and also denial of affirmative action, which is available under the Constitution and your Lordship's judgments.
Lordship,
the second part only is one more. We need to have national exams at one level, state exams at different levels, different dates, and in a gap, which actually again puts a spoke in the wheel, is something also which might need to be addressed while your Lordship is looking.
Lordship, I appear for an intervener, Rahul Bajaj, and we have filed an. I'm sorry.
Yes, please. Yes, please.
Yes, Lordship, the intervention application number is 83490. This is in Bhumika Trust versus Union of India. I will straight away take my lords to the suggestions that we have given while as my lord is deciding the practice eligibility criteria for 3 years. We have given certain suggestions on how the reconciliation between the All India judges and in re-recruitment of visually impaired judgments can be done. I'll straight away take my lord to para 16 of my IA, which is internal page number 8. Do my lords have it?
Yes, you point out no issue.
I'm sorry, Lordship? Yes, all right. Yes. Yes. So, Lordship, we have basically suggested 7 suggestions. One is basically to identify that the lawyer is lawyer with a disability. That is also given in the paper book. The second point that we have made is that in the legal in the panel councils as well as in the legal aid panels that are set up by high courts and district courts, there should be reservation for people with disabilities. Delhi High Court has already done this as part of its legal aid panel that I want to cite as an example. BNC basically takes care of that point. Then I'm also requesting my lord to issue directions to set up and have functional accessibility committees in high courts and in district courts so that lawyers with disabilities can get the accessibility support and reasonable accommodations that they may require to discharge their professional obligations. Mike is
speaking.
So sorry. Sorry.
I'll let you know when they are done.
Yes.
Go ahead.
Yes, Lordship, in para E, what we are requesting is Bar Council of India to set up an accessibility fund so that lawyers with disabilities can be provided necessary support in terms of sign language for deaf and hard of hearing, also the quieter rooms for invisible disabilities, and human support for persons with other disabilities. Assistive technologies, my lordship, is not covered within this, but that is something I would like to submit additionally. We are also requesting that regular sensitization of both lawyers, court staff and judges be conducted on an annual basis so that they are more sensitive to persons with disabilities and they understand the issues being faced by persons with disabilities. In Supreme Court, we are recommending that this can be done through SCEURA as well as SCBA. And The Lordship, the other point that we have made is that the PSU and law firm experience has may be considered while calculating the 3 years requirement for lawyers with disabilities. The last point that I want to make, Lordship, is basically Section 21 of Rights of Persons with Disabilities Act 2016 requires all establishments, and my lord, that definition is given in Section 2I and basically 2E and 2V. 2I defines establishment, where we are saying all law offices, which will include law firms or such other establishments as are notified within RPWD Act, to formulate and notify their equal opportunity policy and register it in line with the Act with the Chief Commissioner or the State Commissioner, as the case would be. If my lord would be pleased to allow the IA and take the suggestions on it.
Important, very vital issue you are raising. That is slightly different than the review application which we are considering. So maybe that we will deal with this issue independently and separately.
Yes.
Okay.
Your Lordship, if I may just add, Your Lordship's two aspects. The suggestions which have come are very good. We have on our side, Your Lordships, we have examined all the rules of various high courts. And what we find is that most rules have a hybrid of situations where there is an entry-level practice that is required and then the training is required. We have given in our suggestions, Your Lordships, two high courts specially, Assam High Court as well as Punjab and Haryana High Court, where they have a staggered training period, which is inducted, Your Lordships, and depending on the number of years of experience you have, that is the proportionate training that you will receive post-induction, Your Lordships. And this is specifically suggested in view of the fact that, Your Lordships, in all other employment spheres, especially in civil services, Your Lordships, all the people go and take those exams, Your Lordships, and in the judiciary, only the people who do not succeed in civil services, they come. It is never their first choice, Your Lordships. And secondly, for women, especially, Your Lordships, by the time 3 years finish, their families do not want them to take any professional jobs, Your Lordships. So this restriction, Your Lordships, is actually taking away both the merit of the service and the dignity of the service as well, Your Lordships. And it actually amounts to an Article 14 violation in comparison to other services, Your Lordships. So we have suggested, and we have given it to the learned abacus also, Your Lordships, the staggered training program to remove the bottleneck of access. Let us allow us to take examinations, and depending on how much ever experience we have, that much training will be given. And Your Lordships will see that the Assam model has practical and adoptable model, Your Lordships. The candidates with prior practice undergo shorter training, whereas candidates without such experience undergo extended structured training. And in that, they have rotational court attachment, they have institutional training, and they have supervised adjudication. So this is a model which has already been formulated. In Punjab, Your Lordships, they undergo an entire 1-year training as soon as they are inducted. Same as civil services, Your Lordships. So these are the 2-3 points that we have suggested, and a detailed, Your Lordships, roadmap. And my learned friend's suggestion that there should be a judicial academy looking at it centralized, in a way that might not be workable, Your Lordships, because all the high courts have peculiar language and cultural and social aspects, Your Lordships. So it probably will need to be worked out at the high court level, is my suggestion to Your Lordships. Grateful, Your Lordship.
Lordship, may I just make 2-3 submissions? May I just be permitted to make 2-3?
Your Lordships, may I please be allowed? Your Lordships, I filed an intervening application back in March with regards to women with disability in the 3-year practice. Your Lordships, I would just try to raise a few parameters with regards to concern where accessibility, safety, and societal pressure is concerned, Your Lordships. Your Lordships, please be considered that where women with disability are concerned, their practice is largely dependent upon how accessible the infrastructure is and how their families pertain to their safety concerns and the societal pressure that they have, which already hinders their professional mobility under Article 19, Your Lordships. Your Lordships, please be considered that it's a compounding disadvantage and an intersectionality between gender-based bias and disability-based concerns, Your Lordships. Please be considered that it's humbly prayed, Your Lordships, that before any decision is taken, this please be considered, Your Lordships.
All right. My question is almost same as Mr. Bajaj, I think.
I didn't get that.
My lord,
We'll consider that.
my lord, I am appearing for High Court of Karnataka.
With your
Prabhu
lordships,
Patil is
kindly.
online, my lord.
So
We have filed application.
We don't need views of high courts at this.
No, we are in
No,
difficult
we are not, we
position, my
filed an
lord.
application, my lord. Some urgent application is filed seeking permission to withdraw the notification and issue a fresh notification. My lords may kindly have a look at our application. We had issued a notification, my lords, inviting applications. Thereafter, Government of Karnataka has come out with an order saying that we should have internal reservations. Therefore, my lords, a fresh notification requires to be issued. Just as a measure of abundant caution, my lords, this application is filed seeking permission to withdraw the notification which is issued earlier.
All right, allowed, IA allowed, the High Court is permitted to withdraw the advertisement and issue a fresh advertisement strictly in accordance with the law.
Great.
May I
My lords,
please
I have moved an application on behalf of law officers working in PSU. My lords, we are seeking parity with respect to the exception carved out to law clerks. My lords, the law officers working in PSU as well are engaged with respect to work.
Them at par with law clerks. Law clerks are working with, they are integral part of
My
our.
lords, the reason we are seeking is this, that I'm preparing notes, the work profile, my lords, of a law officer in PSU would be, we have a fixed client. I'm preparing notes. I go to the court, brief the seniors.
With respect to this review application at all.
My lords,
It's not with respect to this review application.
no, my lords, I've moved an application separately and I've served a copy on the learned amicus as well.
We are not an issue with reference to the review application. We
My
are
lords, we'll take.
The review are confined only to the 3 years.
3 years.
Condition. Mr. Jaideep, you are also appearing.
No, my lord, I am for a high court, my lord. I heard what your lordship said, my lord, so I was, my lord.
Exactly, that.
may I be permitted, your lordship, just 2 submissions, your lordship, before London amicus start with your lordship, just 2 submissions, if lordship permit me. I filed 2 IAs before this honorable court on this premise that my higher qualification is an impediment. So lordship has already considered, High Court has not considered our. Lordship, no, I am here in review, your lordship.
See, we have been telling you regularly.
Yes,
that you
your lordship.
approach the High Court.
Absolutely.
And we have told you enough times.
High Court has not considered our case.
you
They said that
go before
you
the
just
High
try your lordship, I'm just on different point.
Judicial side go before the.
Today, I am on purely on 3 years issue so far as review part is concerned. Dropping that issue, I'm not touching it at all. Genesis of the entire case is para 56, your lordship, of the judgment dated 30th of May 2025. And this is born out of Article 233(2) and 272(b) of the Constitution of India. Reason being, the Law Commission's reports have considered, primarily in the Shetty Commission report, that 7 years and 10 years practice at bar is for the higher judicial examinations and the High Court level for 10 years as a experience as a lawyer or the legal practice, your lordship. So that is the genesis that a civil judge or at the lowest rung, there must be some experience. And this has borne out of para number 56 of the impugned judgment, your lordship. This is under review before this honorable court, and this is the impediment which has come up now. And on that parameters, your lordship, 3 years criteria has been put in it. So just 2 submissions to that effect, your lordship. Just wanted to give this before this honorable court. This is on a France model, on a Denmark model, your lordship. And 2 or 3 suggestions which have also, just going to give you lordship. In France, your lordship, it is judges are selected through a competitive examination and then undergo 31 months of professional training before appointment. So my submission is that extensively this has to be. And second one is lordship, on Denmark basis, law graduates can be recruited as deputy judges directly after school or after gaining some experience. So this is not there in our country, your lordship. Some, your lordship, just 2-3 lines here, I'm just reading and then closing it. They assist judges, undergo 3 years of training and must pass a final examination before becoming permanent judges. This model may be useful in India as it can improve judicial strength, reduce case pendency, and provide financial security to young law graduates. So one step ahead of it, that instead of many other options, one more options may be given so that the aspirants can directly be absorbed as deputy judges. They can assist the civil judges, and thereafter final examination has to be there so that they are fully equipped. Your lordship, at the lowest level, it is the best acumen we need Reason being the judgment travel up to apex court, your lordship. That's why the training at the lowest level, as well as in the law schools, and also, your lordship, for the training in the judicial academy is a must to getting into. I'm so grateful, lordship, always.
My lord, now I'm not treating this as adversarial at all. So I'll just, my lord, since my,
Two aspects, just you can.
yes,
One is suppose the 3 year to be retained,
yes.
then how to deferment, how to implement it.
Yes, so my lord, in fact, your lordship might recall, on the very first day when your lordship took it up, I had given a note of suggestions. One of my suggestions was that I can understand today they might be going through some difficulties. Your lordship may have it as a staggered basis. For this year, for instance, in 26, you may not need any experience. 27, 1 year, 28, 2 years, and then finally go up to 3 years. Because, my lord, in my respectful submission, the judgment of your lordships of May 25 has considered this aspect in very great detail. My lord, it's not as if it's just something that your lordships, and the high courts, which are the institutional courts, which are more conversant with this than any of us, and your lordships have that experience, about how the judiciary must function, is their views must be taken into account. And overwhelmingly, the high court said,
High
yes.
courts we know very well.
That's right, correct.
The moment we give a judgment, they will never take.
No, my lord, I'm talking about pre-judgment. I'm talking, not after that. So your lordship may not take into account what they are saying after 25. I'm saying what led your lordships to the 25.
Must have been taken.
Yes, so that's what I'm saying. They were not at all influenced. Now, my lord, your lordship will also see that till 1993 judgment of the Supreme Court, which said 3 years experience is required, even prior to that, always, my lord, the judiciary had people with experience coming in, whether 2 years or 3 years. In fact, pre-independence onwards. 93 judgment said 3 years. Then, my lord, 2002 changed it to no experience required. So only for that limited period, my lord, we've had an experience of, let us say, my lord, 10, 12 years, where there was people with no experience, and the High Court found that it was not good enough to function as a judge. Now, my lord, let us look at what some High Courts are saying about experience. Problem is that if Assam says, if you have 3 years experience, you will undergo less training. Now that 3 years experience is not actual experience in court. The person may get enrolled today, sit at home. I'm not saying it will happen in every case.
No, this is the only thing happened.
Yes.
That they will get enrollment.
Sit at home and prepare for 3 years.
Lawyer will issue a certificate.
You're correct.
You don't have any.
In fact, there's no certificate required.
You don't have any system in the
Certificate is now required after lordship's judgment. So earlier there was no certificate required. All you have to say is from the date on which I enrolled with the provisional enrollment with the Bar Council, I can sit at home, I can prepare for the examination, I did not go to court, and as soon as my 3 years period, and if I qualify, and I can then say, I have 3 years experience as a lawyer, so please, in fact, cut down my training further. My lord, these are the kind of issues that your lordships are faced with. So, but I do believe, my lord, that for certain categories, if not a relaxation in the eligibility can be 3 years. But, my lord, for suitable, for instance, my lord, relaxation in marks for, my lord, persons with disabilities is a very valuable suggestion. Clerkships, my lord, for them and for women as well as, my lord, judicial clerkships and preferences in that. All that, my lord, must follow. That I think your lordships would, I think, agree with me and with the other side completely. But if we carve out categories of people with not 3 years and 3 years, then there'll be any number of categories who will want that exception.
How to implement it?
Yes.
It is to be implemented in 3 pages or in state.
Given to your lordships, although the note is, or shall I just? Yes, my lord, what I had said was, just give me my last note, which I had given to my lord. My lord, just give me one. Note 1. No. Yes, no. No. What did we say to the court about?
No, the only issue is post or pre-selection. The rest will also nobody is in any issue about. The question is, should it be before or after that?
None of us are rooting.
No, nobody is saying don't have it.
The Assam model, we are saying.
My lord, this is what I'd said.
Bottleneck itself should go. Eligibility should go.
My lord, I'd said staggered implementation in the transition period is the heading, while retaining the conditions for recruitment as laid down in All India Judges, so and so, 25 judgment. In the transition period of the next 3 years, fresh law graduates may be permitted to appear for the Civil Judge Junior Division examination. Candidates who clear the said examination shall undergo requisite training in the state Judicial Academy. After the transition period of the 3 years, the 3-year experience may be made mandatory. That's what they are saying. That was one of my suggestions. Alternatively, practice period of 3 years prior experience can be 0 years, 1 year and 2 years respectively for aspirants appearing for the examination in the next 3 years, i.e. 26, 27 and 28 respectively. Thereafter, 3 years practice rule will apply uniformly. This is what I had, my lord, suggested to you, lordship.
All right, we will examine.
Very great.
Most grateful, my lords.
Lordship, I am IA 15143 in 301. Lordship, my humble prayer is that aspirants like me are getting age barred due to there being no exams held since the past year.
We are conscious of this fact that
If your Lordship may extend the upper age limit from the day of All India Judges Association Lordship may
we'll see what is going on.
That may be necessary because
Oblige, ma'am.
elections have taken place during this time.
Also, the disabilities issue will be posted separately, my lords, for the consideration, my lords.
Great.
My lords, I have filed an IEA for intervention on behalf of junior clerks in lower judiciary, my lords. I've been working for over a decade in Odisha, Cuttack District Judiciary. But I've been working as a junior clerk in District Sessions Court in Cuttack, Odisha, my lords. But because I've been
About this separate category, whether you are eligible or not, this is not the scope of the review. Right?
I have, okay.